everyone. Hey everyone, thanks for joining. We'll give everyone a couple more minutes to join and then we'll begin. Hi everyone, thank you so much for joining us today. This is the third webinar of our Legal Ops 101 series, which we started earlier this year. So if you've missed any of the previous episodes, we'll be uploading those to our site over the next week or so, and we'll email you when they're available for you to access. Now, just want to make sure, because I'm by myself today, can you hear me? Can you please put something in the Q&A bit just to say that you raise your hand? Perfect, thank you. Thanks, Kate. Cool. Okay, so today's webinar is all about optimizing your contract function. But before we start, I'm Electra, and I'm the founder and CEO of TLB, which is a legal optimization company. And we help in-house counsel streamline the way they work through a blend of services, including legal services, legal ops, tech, and design. So if anyone has any questions through the duration of this webinar, please leave them in the Q&A button below. I will try to get to all of them at the end. And I'm also going to be sending the slides and a recording to you all after the session. So people always ask, are we going to get the slides? Yes, you are, and you'll also get a recording, so you can socialize that in your organizations later. Today we're going to spend 10 minutes at the end of this webinar to talk about TLB. So if you want to stick around and find out more about what we do at TLB, please feel free. Otherwise, feel free to drop off. Okay, so we're going to get to the meaty bits now. This is all about optimizing your contract function. And what we know, I want to start with some context first and why this is important. So legal needs to drive the business forward. We all know that the legal isn't just there to protect the business, it's also there to drive it forward. Now, the two objectives are completely different, right? They're kind of opposite, because protecting the business is almost holding it back from doing certain things. In a lot of instances, driving it forward is taking risk. You have to take risk in order to drive a business forward. So these two objectives are differing, and lawyers have a hard job because they've got to balance these two. But my view is that this tension is really healthy, and it's good to have both perspectives. And the reality is that if you're not fully aligned with your role as a function that exists to support business objectives, and you're only focused on risk mitigation, you're not delivering the value you could be to your business. So taking a purely risk mitigation approach to your function will put you in a silo, is the reality, and it will lead you and the business to speak completely different languages and create constant personal brand damaging conflict, leading to you being unable to influence at a strategic level. And that's the reality. So legal does need to drive the business forward, and it needs to be in a position to do that at scale. Now, the reason I say at scale is because legal is traditionally one of the most under-resourced teams in any organization. Now, this stat here that you see in front of you is one that we collected through our One NDA initiative. We did various surveys with our very engaged audience, and you probably took part in some of our surveys, so thank you for that. We found out that the average ratio of lawyers to employees in fast growth organizations in particular was 1 to 100. Now that number is even lower in larger enterprise organizations. So legal teams are always under-resourced really and stretched. So you need to make sure that you're setting yourself up for scale so that you don't slow down the business after it gets to a certain size or to a certain level. And scalability is important, not just for fast growth organizations, but also in enterprise, particularly in today's financial climate. According to the IMF, growth is set to decline over the next 2 years, and that will also have an impact on hiring. So thanks to our friends over at Juro, who recently released their 2023 Tech GC research paper, 75% of respondents said that headcount is frozen or decreasing. So this is a problem that will persist, and yet legal teams spend on average 65% of their time on low value contract work. We speak to lawyers every day, and this is the #1 complaint we hear, that they want to focus on the more strategic, fun work, the work that really adds value to the business. The reason they became in-house counsel, they want to be able to influence decision-making at, board level and improve their product or commercial offering, but they don't have the time or the headspace to do it because they're inundated with low-level BAU contracts. And the depressing thing is that this stat hasn't really changed over the last 3 years. So again, thank you, Juro, for this amazing research paper. If you haven't seen it, please go and have a look. Legal's top 3 biggest concerns are: 1, being buried in low value work, limited budget and resource, and aligning priorities with the business. But these priorities have not changed over the last 3 years. So the question is, why? Why have these changes not been made if these are our priorities? Why are we not nailing our priorities as an in-house community? So lawyers are people, and my view is that one of the reasons is that I think lawyers think that the way to achieve more productivity is hiring. So hiring, when we speak to people, and I've conducted a lot of user research over the last couple of months, and again, if you've participated, thank you. Most people, when I ask them, if you had a magic wand to solve your problems today, what would you do? They say, I'd hire more people and I would get more headcount, which is a completely legitimate thing to want to do. But it's not scalable. And lawyers are people, and we're trained that solving problems comes from other experts, and it's part of our psyche to think that people are the thing that are going to solve our problems. But again, it's not scalable. And the most commonly perceived solution to the too busy problem within the in-house legal community is hiring more people, when in fact, it's not necessarily the best solution. Because hiring more and more people is problematic for a few reasons. If we move to the next slide, pulling more people into low value contracts is problematic. And that's because A, it's not scalable. You can't keep growing your headcount every time you're given more work because you probably won't have the budget for it. And you'll also create a huge management overhead that will stop you from being agile. It's hard to motivate people because lawyers didn't study law to relentlessly review low value contracts. And I've personally worked in organizations where this has caused huge attrition problems. You know, lawyers, they want to do challenging stuff and reviewing NDAs or low level agreements because they have to be done urgently. It's like the perfect combination of boring and stressful all put into one because there's this deadline and then, you know, it's not the most challenging work. So it's hard to motivate people to do that forever. And it doesn't solve your long-term problem. So a huge factor as to why your team is inundated with low-value work isn't because you don't have enough people. It's because your underlying processes are not in place in order to allow you to scale what it is that you do. A small number of in-house legal teams that are intent on being true commercial enablers in their business realize that the real problem lies in the processes that underpin the legal function. And they also realize that there's a need for a blend of skills to truly create a function that scales, including legal, design, and tech. And the result of the way that these teams work is that they have slick operations with minimal waste. They don't waste time doing things that they shouldn't be doing. Lawyers have time to breathe so they can focus on business priorities. You know, as a lawyer, you're faced with loads of micro decisions that you need to make on a day-to-day basis that could have an impact on your business. But if you don't have the headspace to really think about things, and you're always, you know, in overdrive, it's really hard to take everything into consideration and truly advise the business on what it is that it needs to do. You're not spending management overhead on people that are not working on important matters. It's really difficult for you to constantly be context switching. On the one hand, you might be managing people that are doing really strategic, important, interesting work. And then on the other hand, you're answering questions about, I don't know, a liability clause, which I'm not saying isn't important, but you are constantly context switching, and that management overhead is difficult for busy legal teams to have to also contend with. And finally, this is probably the most important point, you're not a bottleneck, so you're building a strong internal personal brand that then allows you to influence the business at a higher level. And, you know, when we speak to people that are not lawyers in a business, what they say about lawyers, and this is not pleasant, is that lawyers are a bottleneck. And you know that, we know that, that's what lots of organizations or lots of stakeholders think about the legal team. And that's because, you know, we have other important priorities that we need to work on, and unfortunately getting things done really quickly on a constant deadline is hard. Okay, the result, what an optimized contract function looks like from our perspective is that firstly, your contract speed is aligned with business needs. So depending on the nature of your organizations, you're going to have a certain speed that you need to hit. If you're a sales organization, you need to be getting those contracts out quickly. Otherwise, you are literally impacting the bottom line. Business is empowered to self-serve. That's the second criterion, because we want to enable the business to self-serve. Lots of times we think that, or we might not think that, but the rest of the business might think that, you know, this is a contract, therefore it's legal. That's not necessarily the case. A low value, low risk agreement that is written in a way that anyone can understand, there's no reason why a salesperson can't pick that up and do it like an NDA. Because the same way they might work with order forms, they should also be in a position to work with lower value, lower risk stuff as well. And you need to be in a position to empower them to do that, because the more you can put onto the business, the less you need to do internally. You're also data-driven and tech-enabled. You've got the tools in place to do your jobs. Often legal's really, you know, the last team to go and ask for budget to buy tech or to implement tech. And I think that's a very complex matter that I'll probably leave for another webinar, but it's really important that you have the right tools to work. Otherwise, it's just very hard for you to get the data that you need to make decisions that make sense, and also to manage things that can be very manual and time consuming if you don't have the tech to automate. You're also set up for continuous improvement through consistent iteration. You don't just set your function up and move away. You've set your function up and you've got processes in place to monitor what it is that you're doing, gather the data because you're data-driven, and figure out what it is that you need to do so that you can become better and better and better, and therefore you're growing with the business. And finally, you're perceived as a strategic business partner because you're not a bottleneck. You really get what the business is trying to do, what the priorities are, how they're changing. You're doing that because you have the headspace, the time, and the influence to get that information. And if you can achieve all of these things, then you will be an optimized legal team. But of course, you can't do that if you're spending 65% of your time on low value contracts, which is what the majority of legal teams are spending their time on. Okay, so poll time. This is how we perceive the optimization scale. So on the left-hand side, you'll see what a reactive team looks like, what an aware, and then you'll see what an aware team looks like, proactive and optimized. So I'll give you a moment to read through these, and then we're going to pop a poll up and ask you to rank yourself against this. Okay. Let's get that poll up. If you're still reading, you can move the poll. Great. Okay. Thank you all for answering. Interesting results. Okay. If you haven't answered, I'm going to give you a couple more seconds and then I'm going to end the poll so everyone can see the results. Okay, so most people are putting themselves in the aware bucket, which is great, and probably why you're here today. We've got some reactive teams, so it's great that you're self-aware. And we've also got some proactive teams, which is great because you're on the way to optimization. And we've got a very small number of teams that consider themselves optimized. So thank you. Okay, so what I'm going to do today is take you through 7 steps to optimize your contract function. So I'm going to take you through 7 things that you can do to transform and optimize your contract function. So the first thing I would recommend to any legal team is that you go ahead and create a legal front door as the first step. I say this because it's just transformational, a legal front door, and it's a controversial topic because often teams don't want to seem like they're being transactional. They want to be perceived as a business partner. But the reality is that if you want to scale with your business, and if you're in a business that's growing or is fast moving, which is most businesses today, it will be very, very difficult for you to do that if you don't have the systems in place to prioritize what it is that you're doing and to have the data in place so that you can make decisions about what you need to do to further optimize your contract function. So a legal front door is a single entry point for managing incoming legal requests from business stakeholders. You can use it for your contracts, but also for other general legal queries. And it's basically a central database or ticketing system. You've probably already got the tech to do it. So if your business is using Jira or Asana or even SharePoint, you can just take that and leverage it and use it as a legal front door. And I cannot stress the importance of this enough and how strongly I do recommend it, because we've seen teams who had, they halved their headcount requirement over the course of 2 years because they implemented a legal front door, because it gave them really amazing insight. So for example, if you keep getting queries from your marketing team about a specific clause that they keep negotiating, just as a terrible example, you know that you can now train your marketing team on that specific point so that you can stop the questions coming through. Or if people are constantly asking you to review NDAs, you know that you can implement training to get them to self-serve on your template NDA, and hopefully you've all adopted one NDA by now, so you can direct them to that. But without that data, you just can't do it. And the reason that you should consider this is because, as I said, you can keep track of all your requests. It improves the quality of instruction, so you can provide a very structured way for how you obtain a contract to review. So when we get contracts to review, often what we do is we have to go back and say, are you showing personal data? What's the nature of the agreement? If you front load that effort of asking the questions in a form that then trains the user so that they know that they're going to have to provide this information every time they submit a contract to you for review, then you're improving the quality of the instructions and you're eliminating that back and forth that you have to do before you can even start doing your work. And what you can also do then is use that data that you've collected to report back to the business on insights that they might find really interesting. So it's a double whammy there. The other thing that you can do is triage and allocate requests easily. So you can look at a request and see where, you know, if it needs to go to a more junior member of your legal team or someone who's more senior. So that ability to triage stuff and allocate it easily is really important, because again, you eliminate the back and forth of, oh, it's gone to this person because we thought they had capacity, but you know, they shouldn't necessarily be doing that type of work. You can prioritize requests efficiently. So often you'll get a low value agreement, and because the stakeholder's shouting, they get their agreement reviewed more quickly than someone who needs something that's much higher priority, but they're too busy to shout. So it's really important for you to have that eagle-eye view of what it is that your team is doing from a contracts perspective, so you can prioritize it more efficiently. You can manage your workload and prevent overload. So you'll know that this person has X amount of contracts to review and this person has half of those, so you can manage the workload and have, again, that visibility. A legal front door will allow the business to self-serve if you set it up in a certain way. It gives you that transparency across all your data, and it allows you to report and provide insight. So, for example, if you can demonstrate to your business that this year you've got twice as many contracts, and you do want to hire someone to do that for you, or you want to spend some money to outsource some of the lower value stuff, then that gives you the data you need to build your business case to go and do it. It's much harder if you don't have the data to go ahead and do that. We have a webinar recording of how to build a legal front door and all the reasons why you should be considering that, which will be available over the next few days. And when that's available, I will let you know via email so that you can go ahead and download it if you haven't watched it before. Okay, the second recommendation I have is that you should create a knowledge hub. A knowledge hub is a fancy term, basically, for a centralized place that's public to your business stakeholders and your legal team, and where useful information is stored in a digestible format. You can create a knowledge hub on various tools that you probably already have, including SharePoint, Notion, Confluence, Google Docs, Google Sites, ClickUp. If you use it, we use it, love it. So yeah, you can just have a centralized location where you store all your knowledge. And the reason you need this is because it enables self-serve, as I said, which is key to alleviating your workload. There's no reason for you to do every single thing that is labeled as legal. You can empower the rest of the business to pick up some of the stuff. You eliminate knowledge waste. How many times have you answered the question of who signs this document? If you were to just have an article up on your knowledge hub and just direct people to it, they can go ahead and read it. There's no point in you retyping the same thing in slightly different flavors, but you know the substance is the same, yet you're spending your time redoing it. Often what we see in legal teams, particularly as they grow, is that there's inconsistent knowledge share, which means that one lawyer who's been there for ages might have a certain way of doing it and they'll advise the business in that way, and then another lawyer will advise the business differently, and then you get the business going, oh, but that lawyer said that to me. So if you were to have, you know, a time where you gather all the knowledge and you publish it, then you have a consistent knowledge base that people can use and rely on. And then also often we will get pieces of advice from our law firms, very expensive law firms, and then you put it somewhere, it's saved in your inbox, and you haven't published it anywhere or stored it anywhere. And so a couple of years later, a similar question arises, and then you instruct your law firm again. By having a knowledge base, you will cut your legal costs effectively, particularly if you're in a fast growth organization where you may not know that that person asked for the same piece of advice a couple of years ago. And of course, this is not just associated with your contracts, but it could be. So yeah, you will save legal fees by doing this. Okay, the third thing that you need to do is simplify those contracts. The other day, we had an agreements review, which was 800 pages, and it crashed everyone's laptop. Is this necessary? Complex, long, and difficult contracts are causing you a problem. They're making your negotiation cycles longer. Imagine if you're a lawyer on the other side receiving a 800-page agreement. How does that make you feel? Are you just really looking forward to getting stuck in? Probably not. Taking this design thinking approach, which is basically thinking of your user. If you want to make their lives easier so that you can cut your negotiation time by half, even, you can do that by reducing the number of pages in your contract, but also by simplifying the language that you're using. And all that language that we use as lawyers isn't always necessary. Some of it is absolutely necessary and is needed for your protection, or because there's case law that says that you need to use that specific language, or you need it to facilitate a relationship that's complex. But a lot of it is obsolete and not fit for purpose, or just overly complex for no justifiable reason. And the impact on an organization is huge. And we're trying to do some research now to really understand this. It's quite hard to get that data. But not only are your negotiations going to be longer, you're also stopping more junior legal team members from developing by picking up more complex work. And this is because even if the work is technically not that complicated, if you're using template agreements that are really complicated, a junior lawyer is going to struggle to pick that up. And so one of the major ways you can gain efficiencies is by empowering other members of your organization to pick up some of the more commoditized work, which I've been talking about throughout this session, like NDAs, for example. And it's perfectly legitimate for you to ask sales to run a simple NDA negotiation process based on a playbook, of course, which we'll cover later. But there's no way that they can do that and feel comfortable in doing that if your NDA is 10 pages long and full of legal jargon. You can't expect a salesperson to do that. It's not fair. And a simple agreement is just easier to operationalize, understand, and interpret once it's been signed. So we tend to forget that once a contract's signed, it lives on, and it's there to be operationalized in some instances, such as big IT contracts. They need to be operationalized. And I've been in a position where I've had to do that and get the business to deliver on that contract. But I found it really difficult because it was full of legal jargon and no one wanted to engage. So I had to physically change the contract through change notes to make it more understandable, which is a complete waste of time. We should have just done that in the first place. Here's an example of one of our latest projects that we've done for UNHCR. And to the left, you'll see the previous contract, which was quite dense and difficult to populate. And on the right, you'll see a much more streamlined, visually pleasing, easier to understand agreement. And the reason this is a really good project to showcase is because the UNHCR was sending these agreements to, or is sending these agreements to partners on the ground that don't necessarily have legal resource to review these sorts of agreements. So heavy jargon-filled agreements are really difficult. They hinder relationships. So it's important to really understand your audience and then create documents that are fit for purpose and that are going to drive the outcomes that you need. And as a result, you will reduce your contracts workload because contracts will just be easier to review. And you might look at this and say, well, how do I redline it? Well, if it's a good, fair agreement, and depending, of course, on the nature of your organization, you may not want or need to redline it because all the variables are at one side, at the beginning of an agreement, as we're doing with this. And also one NDA is a good example of that. Okay, and for the skeptics who think that contract simplification means compromising on the legal protections a contract provides, I invite you to read this clause on the left, so the before and then the after. So this is we have a legal design clauses library, which we use when we're redrafting agreements, and we have all the boilerplate clauses that we usually see are in that library. So this is from there. So the one on your right is 50% shorter than the one on your left. It's much more simple to understand, read, and digest. And so if you're a lawyer reviewing a contract that uses language that's in the style of the box on the left, it will be much harder and will take much longer for you to review the contract than if the whole contract is written in the style of the box to your right. And yeah, think of the mental load that you're creating on the other side, and therefore the additional, potentially wasted time when you're reviewing that agreement. Okay. The next step is to embrace standardized agreements. Standardization of commoditized agreements like NDAs, DPAs, or cloud agreements, which bond terms have come up with, makes complete sense in most instances in which you need one of these agreements. And there's no reason for you to not use standardized agreements if it suits your organization. You can also use the fact that they are market standards as leverage. So you can say if someone tries to negotiate, you can say, look, this is a standard, market standard, we're not negotiating. And just having that leverage will eliminate negotiations, and it will also save you time. And they're free to adopt, so go ahead and do that. Okay, the next is embrace negotiation playbooks. Playbooks are documents that outline your company's preferred position against a provision, either in your own template or third-party agreements. And then they set out a common pushback or variation to that position and say whether that's negotiable or not. And if yes, what the fallback position is. Really comprehensive playbooks will also set out the language that you might use to push back on a misaligned provision. So when you strike something out, you create a comment. You should be creating a comment. Otherwise, you invite a second round of negotiations where people will ask you, why did you strike that out? So if you can create this sort of playbook that has that language as well, then you're really streamlining your negotiations and contract review. Also, it stops you from having to reinvent the wheel. I know from when I was an in-house lawyer, I was always reviewing a contract, striking something out and thinking, oh God, I thought of a really good reason as to why I struck that out in that previous contract that I did. I now want to go and open that previous contract and find that language that I used so I can reuse it. Otherwise, you have to think of it again, and it's inefficient. So here's a mock-up of our sample playbook. These typically live in Excel, or if you're really techie, you can buy tech or other certain features in CLM platforms like Optimise, for example, is both a CLM and also automates your playbooks for you. So you can build this in Excel or just in a Word document, and then you can implement CLM or another tool to help you automate it. So when you're reviewing a contract, you've got a panel on the right that tells you where there's a misalignment in your agreement with your playbook, and then it will give you the language that you need to use in order to rectify that misalignment, and also will give you the language so that you can add a comment. So when you send it over to the other side, they won't have a question as to why you did that, because you already answered that question, and that will eliminate another round of negotiation. And there's other reasons for which you should be considering a playbook. It creates consistent negotiation processes through this standardized approach. Often on a Monday, if you're feeling really refreshed from the weekend, you might have the energy to push back on something, and then on a Friday you're ready to go home and you don't really have the energy to push back on something. I'm not saying that you do that, but we do often see completely differing approaches depending, even if it's the same lawyer. So by standardizing that position that you will take as a legal team creates a consistent contract landscape across the board. You're also sharing the risk of the business. What we've seen often is that lawyers will apply their own risk appetite and threshold to contracts that they review. But by creating a playbook, you've got the opportunity to set out what you think the preferred positions should be, and then ask the business to sign off on those positions. And if they've signed off, then you're reviewing without that constant kind of nagging, am I okay to accept this in the back of your heads? There's no more reinventing the wheel, as I said, which creates immediate efficiencies. And you can also monitor and continuously improve performance of your preferred position. So if you've said, I will never accept uncapped liability, but then you end up almost half the time accepting it for DP and confidentiality breach, for example, then you know that you can change your preferred position. because there's no point in you always trying to win the best possible position. What you want is efficient contract negotiation, because ultimately, if you know that you're going to fall back on that, so you might move that from a fallback to your first preferred position, which will then, streamline your negotiations even further. Okay, so the next step is get CLM. This is controversial. It can be controversial because many lawyers don't think that they need it, and often that's correct. Depending on the size of your organization, the number of contracts you're having to administer, you may not need a CLM. It might be overkill, but if you want to scale your contract function after a certain size of business, then you do need a CLM. And here's why you might need it. Effectively, scale is almost impossible without CLM after a certain point. As I said, you want to digitize your contract processes to eliminate errors and missed deadlines. Often you've got extra work that gets created because you have missed a renewal deadline, and now you need to enter into like a minor dispute with the other side, or write notices to try and terminate an agreement. You can just get rid of that pain. Transparency in your workload for better team management, so you can see where things sit. You reduce your risk because you're monitoring your agreements better, and you save money for your business because you're not spending loads of time doing manual work. So you can deploy your lawyers to do more valuable work. And then finally, data. You've got data insights so that you can make better decisions and drive the business forward. Okay, finally, the last step is making sure that you get help when you need it, including help from internal teams like your IT team to leverage existing tools, for example, or help from external partners like TLB. The reason that you want to consider getting help is that building in-house capability for non-strategic work takes you away from work that matters. I'm not saying that setting up your operations is not strategic work. It absolutely is. But if you have a merger or acquisition happening, that's really where you want to focus. You don't want to be focusing on how to streamline your NDA process or getting or actually running an NDA process. You want the business to be able to do that. And if you need to leverage external or internal resource to do that, then you should. And it might seem low value, but the impact of not being done is high. So for example, lots of people outsource their lower value contracts, and that's a strategic decision that they take because they realize that if they spend 65% of their time on lower value work, they could be freeing up that time for the things that really matter, things that are going to make their company's products better, things that are going to make their commercial offering better, things that are going to allow them to pick up risks that the business might be exposed to and advise accordingly to alleviate the business from that risk materializing. So that's the stuff that you really should be doing. And often people think that lawyers think that they should be doing everything, but if you consider what's low value versus high value to you, then you want to think about outsourcing it or insourcing it even. Of course, the impact of that work not being done correctly could be high. If you're not picking up key risks in agreements consistently, that could be a problem later on down the line. So you want it done properly, but you don't want your team to be inundated with it. Okay, so to recap, the 7 steps to optimizing your contract function are: number 1, get a legal front door. As I said, we have a webinar on that you can download, or not download, stream. Build a knowledge hub. This is really easy, and you can just throw a load of knowledge in there and then figure out how to make it a bit more taxonomized so that people can navigate it. If you're going to start this sort of project, don't worry about making it perfect and figuring out the taxonomy. You can even just start by putting it all in a Word document, and in time, through constant iteration, you can you will make it better. Template simplification is absolutely key. Use templates to your favor, streamline them and make them easier and simpler and quicker to negotiate, and also to manage post-execution. Adopt standards like One NDA. This is just such I say quick win. For some organizations, I realize it's not, because you need to go through the internal adoption journey. But if you start that now, then you can get there at some point, and that will give you a lot of leverage. We're hearing amazing feedback about One NDA and how it's really cut negotiation times right down. Build playbooks, they do take time, but they're absolutely worth it. Create a consistent landscape and also eliminate any duplication of effort that you might be experiencing now. Think about CLM. It's really important that you digitize and automate your contract function so that you can better manage it going forward, get important insights so that you can make good decisions later, and also think about how you're going to scale your legal functions so that it scales with the business. And finally, get help when you need it. Okay, I'm seeing a few questions here. Do you have any tips or advice on how to win hearts and minds and budgets of legal leadership where they aren't keen on a move to optimizing contract systems? Often because they aren't in the trenches, they may not see the need for improvements. This is a fantastic question. And what I would say here is that you do need data. It's really difficult to go, I mean, we're lawyers, we understand the power of evidence. It's really hard to win hearts and minds if you don't have that data. So you want to be thinking about why you need this and what the business case is. And depending on who you're pitching to, you want to be pitching to them by considering what it is that they care about. And to do this successfully, it's really important that you understand their priorities. Firstly, their priorities in their roles. So legal leadership, what are their priorities this year? What's the CEO told them that they need to achieve? And then depending on their priorities, try and think about how optimizing your contract function will help them achieve their priorities. It's whenever we're trying to persuade anyone, it's about making it about them. It's really hard to win hearts and minds when you're talking about how it's going to help you do your job easily. You want to tell them, I can help you demonstrate that you have reviewed double the amount of contracts because the CEO said that you need to do that. That's, again, probably a terrible example, but think about what their priorities are in their roles, and then also as individuals. Try and get to know them a bit. Figure out how they like to be communicated with and what it is that they really care about. Someone could be really passionate about people development and making sure that people are very motivated for their roles. If you can tell them that, look, we're losing good people because they don't want to be reviewing NDAs all day long, that's a really powerful argument for someone personally. So that's how I would approach it. Think about their role, what their priorities are, what they want to achieve, and how what you want to do is going to help them do that. And think about their personality and their personal motivations and drivers. Try and hit both. And it takes time. Often we're tempted to kind of go into a conversation and just ask what we want, but these conversations should be planned. So think about your business case and how you're going to hit those two areas. I hope that helps. What tips do you have to agree with stakeholders on the company's position on each item? Well, I don't think that you're necessarily having to get, I don't know whether you mean on the playbook here, but if you do, you don't have to get them to agree. You can just say to them, what do you think is right? Do you think that we should be accepting uncapped liability? If not, why? And actually, this is slowing us down. So you would put the positions to them and the arguments and see what they come up with. It's kind of not our job to persuade them. It's our job to get their sign off so that you can then apply that throughout your contracts. I hope I've answered the right question. Okay, someone's saying that they do not agree that adopting a fallback position as a new standard to keep contract negotiation efficient. The role of the legal function is to protect the company against risk. Even if we concede on a point 50% of the time, the other 50% not conceded is still a win for the company. Wouldn't you agree? Great point. I don't know if I agree. I think that you need to think about the business case here, because if your priority is to always get the best possible position for the business versus getting through agreements really quickly so that you can help the business go forward, and actually the risk that you're taking by not conceding to the best possible position is allowing you to review contracts so much quicker, then yeah, it's a cost benefits analysis. But yeah, appreciate your comment, Thomas. Okay, so for anyone who's interested, I'm now going to spend a few minutes just talking about TLB and what we do at TLB and how we can help you optimize your contract function. So if you'd like to hear more, please stick around. Okay, so TLB is a legal optimization company, and we've helped over 350 legal teams optimize the way they work. And we do this through a unique blend of skills that not many organizations have, and that is legal, design, and ops and tech. And we believe fundamentally that the future of the legal function will include these three elements in order for it to work in the way that today's businesses need their legal teams to work, so that we sit neatly in the, so TLB sits neatly in the intersection of these three. And there are three predominant ways that we can help you with your contract function. So first, we offer a really comprehensive subscription-based contract review service, whereby we act as an extension to your legal team by really integrating with the ways you work. And we take on your heavy workload so that you can have space to breathe. We have a UK-based, an all UK-based team of highly qualified lawyers, and we work at speed with a 1 to 3 day SLA. So you would send us your contracts, we would review them, negotiate them, and send them back either to you or to the internal stakeholder, or even to the third party. So we work in the way that you want us to work. We don't have a one size fits all. We bespoke our service to you. What makes us unique is that we don't just review your contracts, we also optimize your contract function as we go along. So we'll build out your playbooks, we'll revise your templates, we'll offer continuous improvement recommendations on the way you work, which we know really well if we work as part of your team. We'll see all the friction firsthand and experience it. So we'll be in a great position to offer you these really actionable recommendations that you can implement on the way that you work, so that you can create an optimized function. And our objective is to take away your heavy lifting so that you can breathe, but in parallel to make sure that you're getting continuous value add from us by optimizing your function in the process, because we think that that's key to a long-term relationship. So we'll review your contracts and optimize your function all at the same time. The second service we offer is our legal ops and tech offering. So there are two ways we can help you here. One is through our legal ops as a service offering, where again, it's a subscription-based offering, and we act as an extension to your legal team, either as your legal ops function or to complement your existing legal ops function if you have one. We also work on a project basis to help with discrete projects, such as building out your playbooks, your knowledge hub, your legal front door, or if you're about to buy CLM, we can help you choose the CLM based on the requirements, which will help you gather and articulate and prioritize. And then we can help you find out the best CLM for you. We have a directory that we're about to launch over the next couple of weeks with various CLMs and all the features that they offer. And then we'll map your requirements against that directory and provide recommendations, so you don't have to spend your life on various demos of various legal tech directories, various legal tech tools. And then from there, we can help you get tech ready. So if you're going to buy a CLM that requires you to automate documents in a specific way, so we know that there are some CLMs that, for example, you can't have tables in your documents. We can take your documents, simplify them so that they're easier to self-serve with, but also make them optimal for the tech that it is that you're buying. And finally, we offer an information design service where we focus on really transforming your policies, contracts, and other documents to make them more user-friendly, digestible, and in the case of contracts, easier and quicker to negotiate and manage post-execution. And for some clients, we offer the full shebang. So that's a combination of all our services on a subscription basis. So if you were to work with us in that way, here's the process of what working with us would look like. So this is an example only. We would tailor this to your needs, but firstly, we would begin with a discovery session. And here, this would be a tailored discovery session to really map out your processes and any pain points that you have with your contract function or your legal function more broadly. We then benchmark you against industry peers and create a bespoke 12-month or even longer, 36-month, if you like, optimization plan, depending on the size and complexity of your organization. After that, we would set you up. So this is a really important piece, and this setup will just make us more efficient going forward. So we'll set you up, we'll create your playbooks, we will redesign your contracts, we'll make sure that everything that you do is aligned with your roadmap and your priorities. And then from there, once we've set you up with all the things that you need, then we can go ahead and deliver. So once we've created your roadmap, we will then deliver against that roadmap. And if you're sending us your contracts, we will start reviewing your contracts and completing the negotiation process for you. And depending on the subscription-based service that you're on, you will get biannual or annual or quarterly optimization reports outlining areas that we think need attention so that you can continuously optimize the way you work. And that really is the only way to have an optimized contract or legal function, because once you set it up, you need to constantly review what it is that you're doing, because your business is changing, the world is changing, appetites are changing, people's way of drafting is changing, regulation is changing. So you do need to keep on top of what it is that you're doing so that you can make sure that you're iterating. Any good product requires iteration for it to be great, and that includes your legal team too. Okay, and finally, we have an amazing team. So here's the team. It's a great team of lawyers, trainees, ops experts, design experts, and they deliver the work day to day. So we have myself. I'm a 15 years qualified lawyer. I've worked in various organizations, large organizations, and I started TLB 6 years ago. So I've worked with very many clients, and I still work with clients to help them design their processes and projects. We have Roisin, who used to work at Linklaters, which is where she trained. She then moved on to Circle, which is a fintech, and then she came to us as TLB, and today she's our CCO. We have Rob, who recently joined us from ITV. I say recently, it was about 5 months ago. We have Katie, who trained with us and is now senior legal counsel. Georgia, who joined us from a legal tech company, Leap. We have Kavisha, who is actually on the call right now behind the scenes working on these slides. Kavisha was our first employee and is still with us almost 5 years on, and she does lots of legal ops, tech and design projects. We have Kira, who trained with us, and she's a legal counsel. And we also have Lucia, who is currently training with us at the moment. Okay, and we finally, just a bit of a humble brag, we have an 80% retention rate, so clients are really happy with us, and once they work with us, they want to continue coming back and working with us. And these are some of the testimonials from some happy clients that have very kindly allowed us to share this with you. Thank you all for staying on to hear more about our services. And if there's anything you think we can help with, please don't hesitate to reach out to me. This is our website, that's our email address, but my email address is electra@tlb.law. And if you haven't connected with me on LinkedIn, please do Electra Draconas on LinkedIn. Have a great rest of your day and stay tuned for the next webinar coming soon. Thank you.